thank you for coming out to attend the Alabama State Bar's Pro Bono Celebration CLE for this week. I think this is our last one. We have a really tremendous speaker to close us out. My name is Joseph Abrams, and as I indicated earlier, I have the awesome opportunity to introduce our talented, dynamic speaker for this afternoon, Ms. Cameron Dawson. Ms. Dawson is a senior staff attorney at A Better Balance, which is a nonprofit legal advocacy organization with a mission to use the power of the law to advance justice for workers so that they don't have to worry about caring for themselves and their loved ones without risking their economic security. Ms. Dawson works in the Southern Office on policy advocacy, litigation, and public education on issues ranging from pregnancy accommodations to paid leave. Ms. Dawson graduated from the University of Georgia, and she earned her JD from the University of Tennessee College of Law. So Ms. Dawson is going to speak to us for this hour. We are reserving some time at the end for questions and answers. So if you would just indulge us if you have some questions throughout the talk, if you just wouldn't mind just putting those in the chat box, and I'll do my best to kind of sift through and raise some of those to your attention, Ms. Dawson. So thank you.
Thanks so much, Joseph, for that wonderful introduction. And I will say, as someone who went to both UGA and the University of Tennessee, I appreciate the open arms and the open hearts for those inviting me into this space. And, just wanted to share a little bit today about our work at A Better Balance and the opportunities we have for attorneys to help with pro bono work or attorney referrals, but also to join in this space as we're working to make the state of Alabama more inclusive and supportive of working families. And so today, as Joseph said, if you have questions, feel free to put it in the chat or the Q&A button, and we'll definitely try to save some time at the end of this presentation to address some of those questions. And then I also wanted to hear from folks what they think, so we'll be able to go through some poll questions as well where we can interact and we could see, what everyone knows about employment law. And so today I'm gonna talk more about advancing equity in the workplace through the law, and we'll be able to share this recording afterwards. So if you're not able to see or hear, you'll be able to revisit the recording in space. And so, as Joseph had mentioned earlier, A Better Balance is a national legal advocacy organization with offices. We have offices in Montgomery, Alabama, as well as in New York City, Nashville, where I'm based, and Washington, D.C., and Denver, Colorado. And our main mission is to use the power of the law to advance justice for workers so that they can care for their own health or their loved one's health and not risk a paycheck. Oftentimes, we hear from workers who have questions about whether they can ask for a lifting restriction at work while they're pregnant, or if they have access to medical leave or FMLA. And we often see that their employer may not be forthcoming about that information, but they can call our helpline or see our resources to learn more about their rights and have those critical conversations with their job and not risk, having their hours cut or potentially losing their job for caring for their health or their family members' health. And we do this through three main strategies: legislative advocacy, as well as litigation and outreach and community education supports. And so we've had some major cases with larger employers such as Walmart, who may be, unlawfully pointing workers for asking for accommodations at work or needing medical leave, but we really do try to inform workers of their rights and the ways to enforce them throughout the state of Alabama. And some other priorities that we work on are lactation accommodations as well for those who may be returning to work after childbirth and need nursing break time or space. And we also work not just with mothers, but also fathers and family members who are caring for loved ones who may have a serious illness. So for those facing caregiver discrimination or maybe have questions around paid sick time or paid family and medical leave, we cover those issues as well as our key priorities. And lastly, I'll just say a little bit more about defending local democracy. Preemption is very strong in the South, especially where many states do ban local governments from implementing policies that may be critical for their constituents. And so we work to make sure that local governments know their rights and can try to repeal negative preemption laws that are on the books. And then, along with our paid family and medical leave work, we work to ensure that family and medical leave laws have inclusive family definitions, because as we have seen, not just in 2020 and 2021, the definition of family includes more than just your child or your parent or your spouse. Many folks are taking care of their grandparents, they're taking care of their aunts and uncles, and they're also taking care of their partners. And so having those inclusive family definitions really does ensure that families across the state have that economic security, but also maintain their health and well-being while working safely. And so, just to share a little bit more information about myself, feel free, if you have questions that we're not able to address, to email me, or if you're interested in partnering with A Better Balance to learn more about these key issue areas and legislation around them. I do work on state and local policies, but we also do some federal legislation as well and lead on those critical campaigns like the Pregnant Workers Fairness Act and the Paid Family and Medical Leave Act. So, happy to share more, talk more afterwards if folks are interested in these areas. So just a little bit more about why these issues are important to make sure that we're advancing equity in the state. And what we've seen about the status of women in Alabama is that workplace supports can be really critical in making sure that women and families are connected to the workforce. The March of Dimes recently gave Alabama an F on its 2021 preterm birth report card. And this is a tool that studies the rates of preterm birth across the country, ranging from A to F. And Alabama is one of the lowest states, with a 12.9% rate of babies in the state being born premature and preterm. And the preterm birth rate is higher among Black women at a rate of 52% higher than the rate among all other women. And so when we talk about the social determinants of health, we can't ignore the critical piece that the workplace does play in causing those stressors that lead to those negative health outcomes. And while there are many policies that can impact health in the state, pregnancy accommodations and paid family and medical leave, along with lactation supports, are one of those critical pieces that can help, to make sure that the workplace is not causing, unnecessary stress on workers. And we truly do believe that no pregnant worker in Alabama should have to choose between having a healthy pregnancy and maintaining enough food on the table for their family. Most of women in Alabama are the primary breadwinners for their families. And so when we talk about whether to provide a water bottle or a stool for a worker to use in order to stay on the job versus, being forced onto maternity leave or unpaid leave early in her pregnancy, it really is an impossible choice to force a worker to go through. Now, currently, and I'll talk a little bit more about this, Alabama law does not explicitly provide for reasonable accommodations for pregnant workers or workers who have a child, have recently given birth, or other pregnancy related medical needs. And so, when we talk about what is the role that women play in the workforce and how can we advance equity in the workplace, we really do see that these workplace supports can have a positive impact on their participation rate. Studies have shown currently that 52% of working age women in Alabama participate in the labor force, compared to about 63% of men. So providing workplace supports like pregnancy accommodations, paid family and medical leave, or paid parental leave can help increase those figures and ensure that Alabama's economy is supported with all its eligible participants. And I also want to mention that currently Alabama law does not provide any paid family and medical leave or paid sick days to employees at private businesses. Now, there is some federal law that provides rights to unpaid family and medical leave through the FMLA Act. And we do see that oftentimes some businesses will provide their own set of leave of absence policies or medical leave, but it really should not be a choice or a hardship for an employer to pick the lottery of having a good employer who provides these things. We work primarily with low wage workers who may be in physically demanding positions, and oftentimes those jobs do lack access to PTO or to a Family and Medical Leave Act. And so we want to ensure that all workers, no matter their status, have these protections so that they can maintain their health and safety. So let's start off with workplace accommodations. And these laws can apply to both pregnant workers, but also workers who are postpartum, who might be returning from childbirth or have nursing needs while they are trying to pump in the workplace. So I want to start off with a poll. And let's see, let me click one more time. Okay. So you'll see it on your screen here. And the question is this illegal? Now you announce your pregnancy to your boss who says, as soon as you start showing, you'll have to go on disability because we can't have you looking like that in front of our customers. Is this type of statement illegal? And I know we have a couple folks on the call, so I definitely want to give some time to get proper responses before I close the poll. So feel free to answer yes or no. And thanks everybody for your quick responses. I'll give a couple more minutes. Alrighty, and we're about at 61%, and it looks like we're seeing a majority, but I'll share the final answer in a couple more seconds. All right, so you should see here that the answer is yes. So under the Pregnancy Discrimination Act, you cannot be forced out on leave if you are able to do your job. And oftentimes opinions of customers are not a valid excuse for discrimination. And the courts have found that paternalism even, or negative opinions about pregnant workers and their ability to work has been seen as animus, to qualify for a violation of the Pregnancy Discrimination Act. And I'm going to share a little bit more information about that law and how we help workers, utilize those rights. So what is the Pregnancy Discrimination Act? The Pregnancy Discrimination Act is, in a nutshell, a federal law that applies to employers with 15 or more employees, and it prevents employers from providing or implementing unfair treatment to women because of their pregnancy. It does require an employer to treat women affected by pregnancy, childbirth, or related medical conditions the same as other job applicants or employees who are similarly situated in their ability or their inability to work. And so if someone who is injured on the job is able to take leave because of that injury, or there is a sick time or break time policy for those who smoke, then that employee would have to provide break time for a pregnant worker who may need time to access a water bottle, or if they need medical leave but aren't FMLA eligible, then they need to provide a similar access to medical leave. And so this does apply in context with applicants and employees, but also if there's any conditions of employment or harassment that the worker faces because of their pregnancy, they may be covered under the Pregnancy Discrimination Act and protected by that law. Now, the PDA kicks in when you become pregnant, but it may also protect workers who are trying to get pregnant or have already given birth. So for example, the employer or a manager or coworker cannot be hostile or unaccommodating because they think that their worker is trying to become pregnant. So again, that goes to show the employer cannot believe that pregnant workers are less capable of performing the job because they are pregnant or trying to get pregnant, and prematurely fire them or cut their hours because they believe that that pregnant worker may have some inabilities to continue working. And I just want to say too that we've seen cases recently where pregnant workers have brought cases against employers under the Pregnancy Discrimination Act for failure to accommodate them on the job. And we've seen this unclear standard of what can be accommodated and what cannot because of this comparator standard. And it really has, led to a lot of workers not being protected under this law because of the unclear guidance. And initially, discrimination based on sex was outlawed in 1964 in the United States, but women were still routinely being fired because they became pregnant. And this law was passed in 1978, but it does provide minimum requirements, and there does need to be more legislation to provide a clear guidance on what types of accommodations pregnant workers can ask for, but also what are employers required to do, because there is a lot of confusion around what can be provided and what cannot be. All right, so I wanted to provide another pop quiz poll question just to see, what we all know. So let me see here. There's another poll that is going to come up, and oh, sorry, that's the wrong one. But thank you for answering it. So before we get into that poll question, I definitely want to say we're going to highlight some FMLA and maternity leave options as well. And then, we'll be able to see kind of what everyone knows there. But here are some examples of pregnancy discrimination in the workplace. So an employer may not fire an employee because of pregnancy and say, we don't have pregnant hostesses here, you'll have to go. They cannot deny a job opportunity because of pregnancy. For example, they can't say, why did you come in for this interview with that big belly? This is a waste of time. And they can't show, that they are going to cut your hours or show reprimands because you're pregnant. That could potentially be illegal. So these are all examples of what we have heard from our free and confidential legal helpline. Pregnant workers say, and even though it is 2022, many times low wage workers are oftentimes the most affected by rampant pregnancy discrimination because they're not sure of their rights, or they're not sure, what can be done with their employer in these instances. So we did a study called "Long Overdue," as we kept hearing these constant calls from pregnant workers about, what they could ask for in terms of accommodations. And what we saw was that 2/3 of workers were losing their cases under the Pregnancy Discrimination Act. And they weren't, because there was a unique burden on them, they weren't able to find comparators that may have not been pregnant but were given accommodations because they were on the job, only for 6 months at a time, or they had just recently started. There may not have been clear policies that outlined the accommodations their workplace provided, or even they simply could not afford the litigation to pursue those actions. And so in our report, which was recently updated in 2021, we saw that this standard that's set in the Pregnancy Discrimination Act is clearly not working. Workers are forced to, look through what other employees are being provided. And it really is a simple solution to provide a pregnancy accommodation that's reasonable for a worker in a timely manner, rather than go through litigation to pursue this. And most of you may have known about the Young versus UPS standard, where a pregnant worker named Peggy Young worked as a minivan driver at UPS, delivering letters. And this was the landmark case that really sought to interpret the Pregnancy Discrimination Act. Now, she brought in a doctor's note with the lifting restriction. She did what she needed to do under the policies and was unfortunately placed on unpaid leave, even though she could have kept working with that lifting restriction if it was provided. Now, as a result of being forced onto unpaid leave, she lost her health insurance and those crucial benefits that could have protected her and her family from economic insecurity. Now, UPS maintained a policy of accommodating many other groups of workers who might have been injured on the job, or had disabilities, but they didn't have the same policy for pregnant workers. And the Supreme Court ruled that employers may not place a significant burden on pregnant workers. Then that has to show, a large percentage of non-pregnant workers are accommodated, or only a small percentage of pregnant workers are being accommodated by these policies. And so Young versus UPS was a step forward in the Pregnancy Discrimination Act by helping to show that employers did not could not place a significant burden on pregnant workers, but it's still an unclear standard that many pregnant workers are losing and are unclear about their rights when it comes to asking for these simple accommodations to continue working. And so at times, we do hear from workers who might have had a disability while they're pregnant, like gestational diabetes or high blood pressure. And pregnancy itself is not a disability. And so there are some times where we will hear from workers who might have, high blood pressure or gestational diabetes. And we do also say that they have additional rights under the Americans with Disabilities Act. And so that law is similar to the Pregnancy Discrimination Act in that it does apply to businesses with 15 or more employees. But if you have a pregnancy related impairment that limits a major life activity, like your day to day bodily functions, you may have the right to receive reasonable accommodations under that law, so long as it does not impact the business with an undue hardship, meaning it is not too expensive or too difficult for your employer to provide. Now, that is a different standard from the Pregnancy Discrimination Act because it doesn't rely on a comparator standard, but it does say there are some limitations to receiving a reasonable accommodation if it is too expensive or too difficult to provide. So some types of pregnancy related impairments that we've heard from have, and the courts have ruled have been, having an abnormal heart rhythm, preeclampsia, gestational diabetes, but that's not the end all be all. That's not the limited case of pregnancy related impairments. But at times we have seen that courts do get it wrong and may deem a pregnant worker with a high risk pregnancy as not having a pregnancy related impairment that qualifies under the ADA. And so they do have fallen into that gap between the Pregnancy Discrimination Act and the ADA, where they may not be covered under federal law. So it's important to remember with these federal standards what types of accommodations can be asked for and how to really empower workers to have this dialogue between themselves and their employer. Now, it's not always the case that a worker will get the first accommodation they request, but the goal is to make sure that they're having an interactive conversation and they can find an accommodation that works on both ends for the employer and the employee. And so some examples we've seen, under the ADA has been making changes to the workplace to reduce contact with others, especially in times of COVID where, many pregnant workers might have needed social distancing measures. We've also seen temporary changes with some job duties that may not be essential functions. Maybe they can go to another coworker for a temporary amount of time and modifying work schedules, whether that be working in the mornings versus working in the afternoons or nights, and also making sure that it is accountable to that individual worker's needs. And these are the same type of accommodations that also work for workers with disabilities. And so if we hear from workers who may have diabetes or they may have insomnia or anxiety or high stress, if those conditions qualify as a disability, then we do advise them to try to ask for these reasonable accommodations so that they avoid being pointed out or facing repercussions and subsequently being terminated from their job. These are all examples of accommodations that the EEOC has cited in some of their pandemic specific guidance, but also their FAQs for workers with disabilities. And so oftentimes we will tell workers that they can talk to their job, talk to their doctor about what can be done, to ensure that they're able to stay connected to the workforce. Now, before I close up with the pregnant workers and lactation accommodations, I do just want to highlight that right now we've seen 30 states and 5 cities adopt their own version of the pregnant workers fairness laws. And that does go beyond the Pregnancy Discrimination Act to provide reasonable accommodations for known limitations related to pregnancy or childbirth or related medical conditions. And it uses a similar standard to the ADA by saying, these accommodations would need to be provided for unless it would cause an undue hardship on the employer. And this means that unlike federal laws like the Pregnancy Discrimination Act, a worker does not necessarily need to have a disability or to compare themselves to others in order to receive that accommodation, but they can work, with their employer to receive a timely accommodation and not lose out on those critical benefits like health insurance or income to support their families and themselves. And unfortunately, Alabama is not on this list, but you can see that these 30 states have all passed the Pregnant Workers Fairness Act. There has been growing state momentum, and many states in the South are starting to really prioritize pregnant workers in their legislation and pass this with bipartisan support. Now, these laws help workers get the accommodations they need quickly and without conflict, so there's no need for litigation. And in some states, we've seen that there's been a reduction in litigation and it actually improves worker morale because they're able to have these open conversations with their employer without facing retaliation. And even though we've passed some of these laws with state organizations and legislators, it is important for workers to know their rights. So we often do provide that support to workers in these states to know what their rights are, to know how to use the law, and having those conversations with their employers. So how these state pregnant workers fairness laws work, in case you have a client who may be working in another state, is that the process will go where the employee notifies their employer that they need an accommodation that's related to their pregnancy or a medical need related to their childbirth. It doesn't have to be, a disability, or it doesn't have to use specific language, but they may need to notify them that there is a need. And so the employer can then work with the employee on an individual basis to come up with an accommodation together. Now, times we've seen that there may not be space or room for a chair to be provided, but maybe there is an open position that the pregnant worker can be transferred to that is also going to accommodate that pregnant worker's medical needs. The PWFA also states that an employer could not force a pregnant employee to take an accommodation like unpaid leave if it was not necessarily needed by the worker. And that is because, we really do want to make sure that workers can continue to have these conversations, but ultimately choose their own accommodation, whether or not they need it. And they're not forced onto unpaid leave, like in the case of Peggy Young. The bill also protects against hiring discrimination, so it does cover applicants and protections where an employer may not refuse to hire a pregnant employee simply because she may bring up in the interview that she may need a reasonable accommodation or maternity leave later on during her pregnancy. But we do have some advocacy around the Pregnant Workers Fairness Act. And, on the state and federal level, we are working with folks to really ensure that every pregnant worker is protected. And no matter their zip code, we are working with folks on the ground to really push for the Senate to bring this law to a vote on the federal level. And if any of y'all are ever interested in that, feel free to follow us on social media, and I'll be able to share that information later at the end. So the federal law works similarly to the state laws in that it provides, explicit protections for workers. So that way they don't have to choose between their health and their job. And this is a public health measure. It's also an economic security measure that really can provide security for families across the country. And unfortunately, we've still heard from many women who don't live in states that have those explicit protections, that they are still being forced to choose between their job and their health. And many are, forced to either return to work 2 to 3 weeks after their pregnancy because they're not qualified for the FMLA or any maternity leave at their job. Or even, they're forced off of the job if they have asked for a lifting restriction or, access to accommodations to prevent bending or heavy lifting of items. So this is really a critical issue that we're still hearing from today, and it really does call for, more creativity from lawyers and advocates alike to help protect workers who are pregnant or nursing. And so I just wanted to talk a little bit about, what the new opportunities are to support women in the workforce. And, what we've seen is a growing urge to, really protect workers and advance equity. And so this time I do want to bring up the pop quiz again. And this will be the poll question that some of you may have already answered, but we're going to bring it up one more time. Okay, so true or false? Everybody in the United States gets at least 12 weeks off work when they have a new baby. And you should be able to answer true or false to this question. Does everyone in the United States get at least 12 weeks off of work? And it looks like some of you may know your labor and employment laws. I'll give a couple more seconds too. All right, and I'm gonna share the results. It looks like 88% of folks said false and 12% of folks said true. And the answer is false. Now, according to reports from the Department of Labor on the federal level, only about half of the private workforce is entitled to leave of that length. So it's only about half of them. And that leads me to the second question. Let's see here. And thanks everyone for your grace as we navigate these polls. I always say by the time we are used to the technology will be the time to stop using the technology. But feel free to put in the chat if you believe that it's okay, because most employers provide their own maternity leave or paid maternity leave anyway. And if you go under everyone, it should be able. Thank you, Andrew. Okay, I see false. And this is still the paid maternity leave question. We had a little bit of difficulties with the past poll question. So I appreciate everybody putting in their answers in the chat. Right, thank you. Angeline, false, I see. All right. And as most of you all said, the answer is false. So again, and the percent here is even less. So only about 23% of employees have access to paid leave. And what we have seen too is that some employers will have some sort of short-term disability insurance, but there's a very limited number of employers who have their own paid maternity leave policy or paid parental leave policy for fathers as well. And what that does lead up to is, the opportunity even to see if there's a chance to pass paid family and medical leave. Now, what we have seen is that only about 14% of workers in the South receive paid family leave through their employers. And again, this is based on data from the Department of Labor's Employee Benefit Survey. Now, low wage workers and people of color are even less likely to have access to paid family leave, even though they are more likely to depend on every paycheck that they receive. And so that means when we're talking about a serious illness like cancer treatments or returning from the hospital from giving childbirth. If there's no access to that paid family and medical leave, then many employees are forced to choose between, do I take the time off or do I try to work through it and maybe aggravate my injury even more, my illness even more? And oftentimes we've seen that many employees are forced to choose to leave the workforce and care for themselves without that pay and income. And it's often hard for them to come back to work and find a new job because of that gap of employment. And paid medical leave does protect workers where paid sick days may not be enough. So even though there might be some PTO or accrued vacation leave that's provided, paid family and medical leave does go a step beyond and provides that critical support. And so what we've seen is there's growing state momentum to provide paid family and medical leave on the state level. About 11 states, including California, Colorado, Delaware, Massachusetts, New Jersey, New York, Rhode Island, and Washington, D.C., have passed their own paid family and medical leave programs. But there is, you know, growing momentum for state employees to provide their own paid family, to have their own paid family and medical leave on the state level, especially where preemption may stop a lot of local governments from providing that right to all their citizens. So when we talk about local democracy, we really do see, are there opportunities to provide steps for employees to receive paid family and medical leave through policy and the law, or are there opportunities to really see, you know, if there's a chance for it to pass on the state level? But there are a range of strategies that we use to ensure that workers have the time off to care for themselves or their children, you know, in the case of a crisis. So only about 40% of workers actually qualify for the FMLA. And we've seen that the FMLA does have a few eligibility requirements that many folks are not eligible for. You have to have worked at your job for at least 12 months, and you have to have worked there for at least 1,250 hours during the 12 months before taking leave. And that location needs to be within 75 miles of at least or sorry, you need to have at least 50 employees within a 75-mile radius. And so what we've seen is many workers may have just started on the job or they are only on the job for 6 months. And so they are eliminated from that 12-month eligibility requirement. At times, this law does exclude part-time workers, even though, you know, it does provide some rights for full-time workers who may have met that 1,250-hour cap. And then we've seen, especially in the virtual space, confusion around, you know, whether or not their employer is covered under the 50 or more requirement. And that's really provided an opportunity for us to provide clarity on that. But many employees do work at a job that has less than 50 employees. It may be a small mom and pop shop, or they may have multiple locations in other countries. And so, you know, that really does leave a lot of workers outside of the protection of the federal law. And currently, Alabama does not have its own state discrimination laws or its own paid family and medical leave or unpaid leave laws. And so, for many workers working in Alabama, the federal law is its main recourse and protection. Now, while they are taking FMLA, if they are qualified, leave takers are guaranteed continued benefits. So if they are paying 20% of their insurance coverage, their employer needs to maintain that coverage. And, you know, they're not forced to then pay all 100% of their insurance benefits while they're on leave. Workers are also guaranteed the same or equivalent job when they return, and that could be the same or equivalent job that has similar conditions, benefits, pay, if that job that they did have is no longer available, or if there were some mass layoffs that make it a little bit difficult to return them to the same position. And lastly, I'll just highlight that employers cannot interfere with or retaliate against an employee for exercising their rights under the FMLA. And so if they are asking for what their entitlement is, how much leave time they have left, they are not allowed to be discriminated against or interfered with by using those leave allotments. They need to be provided notice of their rights and, also when they return to work, they cannot be discriminated against or harassed for taking that leave. But we often do hear, even though these protections exist, that many employees are, penalized in a sense or fail to be promoted because they've taken FMLA leave. And it really does create a culture of fear and retaliation when other workers see that. All right, so now I will bring up the poll question on the breastfeeding rights, and we'll see if we can share that on the screen. Employers can make nursing employees pump their breast milk in the bathroom. And I did give a little bit of a hint on the slide. So we'll see, if folks see that or before they answer, or, what folks believe is true or false. And thanks again for participating in these poll questions. I know we're living in a virtual world, and it really is important to see how folks think and how we can continue to engage on these issues. But really excited to see how most of you all know these employment laws, and really goes to show the expertise that is here in the room. So I'm going to stop sharing in a couple of seconds, and then we'll go on to the next section. All right, so it looks like 87% of you said false and 13% of you all said true. And under the Federal Break Time for Nursing Mothers Act, or that's under FLISA, but was a part of the Affordable Care Act, this would be false. So if the employee is covered by FLISA or the Federal Labor Standards Act, then she is entitled to pump in a private space other than a bathroom. And like I said, there is a federal break time for nursing mothers law, and what I'll go into the eligibility requirements of that on the next slide. So the Department of Labor also, along with the FMLA, also does look at the federal break time for nursing mothers law, and this law is was provided under the Affordable Care Act, and it requires employers to provide reasonable break time for an employee to express breast milk for her nursing child for 1 year after that child's birth, and also provide a reasonable space that is free from intrusion and is not a bathroom. And so what we've seen here is reasonable break time really is on an individualized basis, and that can be dependent on what their medical provider or doula or midwife suggests. If they're going to WIC and seeing a peer counselor, what they may suggest, but it's based on their own medical needs. So at sometimes we've seen it can range from 20 to 30-minute breaks a few times a day. And that helps the mothers maintain their milk supply and also provide that critical feeding supply to their baby. So that way their baby can maintain their health and weight, and the mother does not develop any adverse health outcomes from failing to be provided that pump time. Now, this law does apply to employers and employees that are covered by FLISA. And so usually we do say that if a worker is hourly and they're eligible for overtime, then they are covered by FLISA. So they're non-exempt. But this does mean that salaried employees, administrative employees, professional employees like nurses or teachers may be exempt from this law and this break time law because they are FLISA exempt. So they're not subject to hourly or overtime restrictions. And in the Pregnant Workers Fairness Act, it does provide some protections for lactation needs, including reasonable break time to pump, no matter if they are FLISA exempt or non-exempt. But we've also seen some states try to implement their own lactation laws separately and ensure that there are explicit protections for nursing mothers. Now, when there is reasonable space. This law does not require an employer to create a new space, but what we have seen is some employers will convert an office space into a nursing room, or if there's a separate office that the employee is working in, they'll allow them to close the door, to put locks on the door, or maybe a sign up so that their coworkers do not intrude while they're pumping. And it also provides that there is a place to store the milk and safely clean the pumps. And that is one of the main reasons why this law does prevent employers from forcing employees to pump in a bathroom, because oftentimes it is unsanitary and there are not many pumps, or plugs to plug in the pump. So it really does advise employers to provide a clean private space. There is a small caveat, though, that even though this law does apply to all employers, if an employer have less than 50 employees, and it would be an undue hardship to provide that reasonable break time or that reasonable space for the nursing mother, then they may not need to comply with the law. But they do have to show that there's an undue hardship. So they have to show that because of their size, their financial resources, or the nature of their business, that it is not possible to provide, that reasonable break time or space. And in that case, if there's a strong showing there, they may be excluded from providing that break time or space. But it is a hard, high standard to show. So this is a lot of information to cover. So along with, these laws and how to explain them to your clients, or even during consultations, and while we are also providing information to callers who call our free and confidential helpline, we also have fact sheets that have a summary of these laws. So that way employees can take them when they go into conversations with their employer, or they can share them with their coworkers and increase that worker power and knowledge. And so these fact sheets are, about talking to your boss about your bump or your pump. And they go through what should you say, what are the health benefits of accommodations, how to be prepared, and what to really cite when you're having these conversations, or if you need, advice with self-advocacy. Now, it also includes, crucial summaries of the laws, so that way folks are informed about their rights. And we try to form these fact sheets with state-specific information, so it's just for Alabama workers, but we do have it for workers across the nation, and they're each tailored to the rights that they have on the federal and state level. And I did want to provide, some insight. We do also provide referrals for workers who we may not be able to take on. And so if you are interested in potentially being on our referral list, please feel free to contact my colleague, Marcella. And I put her email in the presentation, and she, can definitely list you there in a case where we're not able to, serve workers in Alabama. But again, we do try to take on and help workers as they call us. Now, our free and confidential legal helpline is 1-833-NEED-ABB, and we do offer services in Spanish and in English. And so if folks are calling from Birmingham or Montgomery, or anywhere within Alabama, they can call our helpline or fill out an online form. And we do try to give a quick turnaround to make sure that they know their rights, or, if they're trying to share their experience, to push for advocacy, that they become involved. And our social media is also listed down below. You can follow us on Facebook or Twitter if you're interested in updates on the Federal Pregnant Workers Fairness Act, or even the PUMP Act, as somebody mentioned in the chat. We do work on the federal level as well to push for legislation, but we do also work on the state level in Alabama as well to make sure that there are state-specific rights for workers too. And along with being on our referral list, I did also want to talk about our Pro Bono Partnership Program. This is Pro Bono Month, and I'm happy to conclude it with this presentation. But we are interested in partnering with folks who are passionate and dedicated to the rights of workers, and we have developed a network of legal professionals that are committed to defending the rights of women and working families. And that does range from a variety of initiatives. So if you are interested in co-counsel opportunities or resources, or even co-hosting trainings with us in your community, please reach out, and we can definitely talk through some possibilities there. And you can also visit our website to find more about the Pro Bono Partnership Program, and that's at abetterbalance.org. I do want to thank you all, and I want to save some time for questions and see if we have any in the Q&A. But thanks again to Joseph and Melissa and Linda for putting on this great program, and thank you all for coming in and really being excited about how we can advance equity for workers in Alabama. And definitely happy to address any questions that are in the chat.
Awesome, Ms. Dawson. Thank you so much for your time and attention in this matter. I think there's one question that I see in the Q&A box. We also roughly have about 8 minutes, so if anyone has any additional questions while we're knocking out this first one, please go ahead and throw that in the chat or in the Q&A box. Randall's asking if there is case law holding that FLSA exempt employees are not entitled to the nursing breaks. He hadn't heard this before.
Yes, and I'm definitely happy to share that with you offline as well. And what we've seen from the Department of Labor is, their explicit fact sheets have stated that if you reach a certain salary requirement, or if you do a certain type of work, you are therefore FLSA exempt. And so, those workers are not given the nursing breaks. And then even on our helpline, we've heard from teachers and nurses who are not able to request those nursing breaks to pump at work. They're forced to either do it on their lunchtime, or try to make up for the time if their supervisor specifically is more amenable to that request. But yep, I'm definitely happy to share that offline as well, what we've seen. And that means roughly 9 million workers are excluded from nursing breaks, which is unfortunate to think in the United States that we are really leaving folks to the mercy of their employers when it comes to this, when so many mothers are practicing this, especially during a formula shortage. So it really is critical, and we definitely want folks to get involved, both on the advocacy level, but also with our legal partnerships.
Good deal. That's fantastic response. Again, if there's any additional questions, let's see.
Right. Yep, it's definitely, and I think we're also looking at the chat as well. And so if y'all want to put questions in the Q&A or the chat, I'm definitely happy to address them.
Right, and if you can give them your email again, maybe if they have some additional questions offline, might be bashful now. It's always
yes. And I'll put my email in the chat. And also, so on our website, we do have a worker rights hub specifically for employees, but also for other resources, and it goes state by state. So you can see whether you live in Alabama, California, New York, Tennessee, where I am, what each category is, caring for yourself, caring while you're pregnant, returning from maternity leave. You can see those laws listed there. And we definitely have internship opportunities for law students. We have fellowship opportunities for recent grads. And we currently have some openings for all of our offices. So if you are interested in the work, whether it be an externship or an internship, please, apply. And, we definitely are interested in having candidates who are diverse, who are interested in these issues, and just want to get started in being involved in law and policy. Because, as a lawyer, that's not an opportunity that I saw in my law school, but it really is needed to have lawyers in the space working with maternal health advocates and worker organizations. So
fantastic. I think there was one question that floated past in the chat from Prince, asked what states have pregnancy discrimination laws. So that might have been something that you covered in your earlier response. on your website?
Yes, so Prince, that's a great question. So currently, all of the states except for I believe Alabama and Mississippi um, have, a state level discrimination law on the books. In Georgia, there are some discrepancy with state discrimination. So they protect discrimination on the basis of disability and some other protected classes, but not sex or pregnancy. But we have seen then in the local levels, like in Atlanta, there are some ordinances that protect against all protected classes that the EEOC covers. So we are, I think it goes to show the fight for equity in Alabama and Mississippi, and really, trying to bring uh, different policies to the forefront. And these aren't the only policies that advance equity. We've also seen momentum on childcare and Medicaid expansion. And so I think all of these together really does create for a more inclusive workplace for families, for caregivers, for women, just across the board.
Good job. Okay, so our final salvo for final request for any questions. If not, just again, thank you, Ms. Dawson, for your time, for your thoughtfulness and the level of thoroughness in this presentation. I just want to make a last pitch for all those who are attending. If you have not joined the Volunteer Lawyers Program, it's an amazing opportunity to help those who need legal services across our state. So with that, if there's no, let me see, there's might be some more questions here. Okay, are there any ways for law students to get involved? I think you might answer that. Okay, and someone asked if you can share any of the slides because the screen never refreshed after it rebooted.
Sure, and I'll definitely share some materials as well, including the fact sheets and kind of the links that I've shared as well. That way folks can see that and the recording and the slides.
Good deal. All right. Thank you so much.
All right. Thanks to everybody who attended. I really did appreciate your time and grace in this. And, thanks Joseph and Linda and Melissa for putting on a great pro bono CLE month, and, happy to support wherever I can. Thanks for having a better balance today.